when we think of hearings and trial dates, and we always think of open hearings and open trial dates and orders not sealing hearings and orders not sealing trial dates. And we've all watched, throughout our many years on this spinning planet, evidence not being sealed or being hidden from the public. We've always seen evidence being displayed in hearings and in trials and everything else. Why is it different in the state of Idaho? Now, why is it different in the Brian Koberger case? We don't know. Is the prosecution just trying to hide everything? In the last court date, or the last hearing, Ann Taylor is getting tired of all the closed hearings. And she's even addressed it to the judge. And of course the judge came back, well, you did agree to some of those too. Comes now Brian C. Koberger by and through his attorneys of record, and hereby objects to the state's motion to close the hearing to compel on May 14th, 2024. Well, we all know that that court date basically got canceled and moved to the end of this month. The grounds are that Mr. Koberger has a constitutional right to a fair and public trial. No reason exists to prevent him from a public pretrial proceeding, a proceeding that ensures fairness and access to the state's information. Further, the state has made no showing that the hearing should be closed under IAR 32. There is simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents, including, now hear this guys, including the FBI, to hide how discovery is being withheld in this case. The testimony and argument on information sought by Mr. Koberger does not meet the narrow scope of what the state can shield the public from view. The state can shield from public view. The Idaho Court Administrative Rule 32, not only is there no authority to protect the FBI and other law enforcement agents and the state in this matter, this request to deny Mr. Koberger an open hearing is a clear violation of his right to a public trial. See Weaver versus Massachusetts, 582 U.S. 286, 2017. And Walter versus Georgia, 467 U.S. 39, 1984. Sealing of motion to suppress to protect privacy of witnesses was error requiring remand for review. And guys, Ann Taylor is not playing around anymore. She is really not playing around anymore. The state has failed to provide all requested items that were asked for in the defense's supplemental request for discovery to support the charges against Mr. Koberger. Thus, the defense has had to file its fourth and fifth motions to compel. It is not lost on Mr. Koberger that the state is asking for a rescheduling order to obtain information from the defense to be used to support our motions to compel the state's discovery. However, Mr. Koberger suggests a dual deadline for both the prosecution and the defense to file notices of witnesses, exhibits, expert reports, or other evidence relied upon at the fourth and fifth motion to compel by May 7th. Response disclosure by both parties should be due May 10th. Even Brian is getting tired of this nonsense going on. Brian wants a deadline for his own team and the prosecution. Now that part shocked me. Even Brian wants a deadline for not only his defense team, but the prosecution as well. What is going on in this case? It's really, this is a very odd case. And I know I keep saying it, but it is an odd case. Out of all the court dates I've watched on TV throughout the years, all the trials, I have never, ever seen a prosecutor willfully trying to hide stuff from the public. I mean, even during the O.J. Simpson trial back in the 90s, Marcia Clark never did that. She was always fair, and the public always got to see the evidence against the client. Like, everyone got to see the evidence of the gloves from the O.J. Simpson trial. This is the first case that I know of where they're sealing the evidence away from the public view. It makes me think that they have no evidence. And what evidence they do have, they don't want the public knowing exactly what that evidence is. And just like Brian's alibi defense, you have the prosecution saying that's not an alibi, driving around, stargazing. That's not an alibi. If he's stargazing at Wawai Park, isn't that an alibi? There's just so many complexities and intricacies in this case that I was reading on X just a couple of days ago that this trial may not happen for another 2 years. So Brian would be sitting in jail almost 4 years before this thing goes to trial, or a little over 3.5 years before this thing goes to trial. And just like Judge said, I'm not even sure if this case is going to make it to trial. But you guys have a good day, and I will keep putting out content. I will get down to the bottom of this case. You guys have a good day. Peace.